Director Squires, thanks for being here today. Last Congress, I introduced legislation to limit the enforceability of patents by entities on certain national security-related sanctions lists. This is because I think many members believe, state-sponsored entities like Huawei can and do use protected patent litigation to slow or stop critical technologies from being developed in the U.S. Do you see that as the present or future national security threat? And where do you stand on limiting enforceability of patents in those types of cases?
As to limiting enforceability, one thing I would point to is we recently, a couple things in the PTAB. So we restored the real party and interest requirement. And with that, we just issued a decision called Tianma last week, which concludes under the AIA, as with American government entities and agencies, are not persons and cannot be in the PTAB, neither may foreign sovereigns or state actors. And so if a real party in interest is identified, they are not allowed to be in the PTAB and they can't bring challenges. To protect with that in the discretion of instituting IPRs, we have also just released guidance that looks to whether it's a small business in the U.S. or American manufacturing is occurring in the U.S. As part of whether a challenge should be instituted. So to protect American manufacturing and have them choose here. So both sides of the equation, we're trying to take into account what the real world is, and the process for filing a petition, we say, tell us your story, and so we can take these into account.
Very good. Another area where I know many members have concern is about foreign exploitation, and it's all about the patent prosecution highway, right, as it's referred to. Under this program, the USPTO will expedite review of certain patent applications that have received a favorable exam in a foreign patent office. We know that China participates in the program, and therefore an entity like Huawei could receive expedited examinations of its patents so long as it first gets a favorable exam in China, which is effectively a rubber stamp, right? So should we not kind of allow, or shouldn't we be concerned, I guess, about kind of the way that's playing out?
Thank you for the question, Congressman. That is of great concern, and it's a bilateral concern. In general, when cases come in through the patent prosecution highway, they've already been examined, but there always is the risk of rubber stamping. But we do an independent analysis. If it doesn't pass the smell tests, then we kick it and it goes back in line and the prosecution is lost. On the other side, we found for U.S. companies, the PPH has helped them in other countries. So we're trying to always maintain that balance where American companies going into other offices are receiving the favorable treatment. They have behind them the examination that's occurred and hopefully, born strong in the U.S.,
right.
But we're always on the watch for incoming low-quality patents.
Very good. Let me quickly turn to kind of another area. According to American Intellectual Property Law Association, the average cost of patent litigation in a district court is $5 million, whereas the cost for adjudicating patent disputes before the Patent Trial and Appeal Board on average is about 10 times less, or around $500,000. Critics of the proposed changes to the PTAB process have said the result will be more patent cases being litigated by the courts. And assuming that could be true, did the USPTO take into consideration the increased litigation costs when conducting an economic analysis of your IPR rule? And if you didn't, then how did you handle that, and why didn't you maybe look at that?
Thank you for the question. Yes, we're still in the process of finalizing the rule. We have received over 11,800 comments, which we're very excited about because people care. About 2,800 were unique, clearing out all the Me Too ones or clearing out the ones that, we don't like the Patent Office. But substantively, there are about 2,800. And under the IA, we are required to consider economic efficiency, resource allocation to the office, and effects of those sort. And so by all means, we are looking at what the costs are in the rule. I'm optimistic the rule will be finalized, and I believe people will be very happy with the outcome.
What about judges' caseload? Did you take a look at that as well?
Yes, we are looking at all of that in the rule. Judges' caseload, but it's also not just district court forum. What's the effect on reexamination? What's the effect on PGR? And what's the effect also on ITC cases?
Thank you. I yield back.